Be abstaining for the court, all present having anything to do before the Honorable, the judges of Court of Appeals, draw near and give your attendance. For the court is now in session. God save the people of South Carolina and this court.
Good morning. Please be seated. It is good to see both of y'all this morning. Appreciate y'all's cooperation with scheduling. And Madam Clerk, if you would call our first case.
You are on case number 2019-002107, the State versus Ricky M. Dawson.
May it please the court. So what more could the driver have said to express his clear limited consent to search the car in this case? 7 times, actually 8 or 9 times if you count the nonverbal times, the driver made it very clear that his consent to search was restricted.
He tried, but he did equivocate, it seemed. And I watched the dash cam, and that canine is just barking the entire time. And the way I understood the police officer, in addition to jumping around about what he wanted to search, he clearly wanted to get into the whole car, everything in the bag. But as I understood it, the baggie he thought he saw was in the driver's pocket, right? Or not? I'm trying to figure out. So at the very beginning of the dash cam, there's a baggie discussion. He says, I saw a baggie. I know I saw it. You've put it back in your pocket. What's in the baggie? Now, was that Mr. Carr that he was having that discussion with?
That was the driver. When the car was stopped and the officer approached, he said that he saw a glass baggie in the driver's seat, in his lap. The driver stated that, no, this is a candy wrapper. I would bring to the court's attention that this glass baggie, this candy wrapper, was empty. There was nothing in it. I would also bring to the court's attention that it was never found again during the search, before the search, or after the search. Our position is that this did not rise to the level of probable cause, all right? We don't have a glass baggie.
How do we know the baggie was empty? I don't think we ever knew whether it had anything in it or not. He saw a baggie, but he never saw it again, so we don't know if it had anything in it, if it was empty, it was just trash. I mean, I don't think we really know if there was anything in the baggie, do we?
Well, we're drawing the inference from the fact that the officer said this looked like the type of baggie.
But then nobody found it, right?
But nobody found the baggie. So that's why we draw the inference that it was empty and it was never found again. So
I don't think we draw the inference that it was empty. The inference I would draw was that there was no baggie. And if I hadn't heard the back and forth discussion on the dash cam, that would have been I think, a fair inference to draw. But it just correct me on this. It seemed to me when the officer said, well, you don't have to consent. I could get the dog. And he's right there. We have case law that if you don't detain the stop for too long, they can have the dog walk around the car. Why was that wrong? Because he did seem to cave because that dog was going nuts.
So we look at this whole back and forth between the officer and the driver under the totality of the circumstances. So we have to understand that in the end, when the dogs were threatened, they were threatened to bring the dogs out, this go-ahead really has to be predicated upon the entire conversation. And this is where the driver said, just the car, not my passenger, not Ricky Dawson, I'm just agreeing to the car. At first, he said, I'll agree to the driver's side. Then it expanded to the car, but he never relented with respect to the passenger and the passenger's backpack. That never happened. He was steadfast, and this did become a little coercive after a while, back and forth. But it was very clear. There was no ambiguity here. It was very clear that the driver had no apparent authority to consent to a search of his passenger's backpack, that being Ricky Dawson.
And what do you base that on?
I base that on the fact that, well, number one, we know that the officer testified that Ricky Dawson was in direct control of the backpack. It was at his feet, at his legs. The officer knew this. He stated this during the testimony, and he was quite candid, the officer, with respect to the fact that he would not have allowed Ricky Dawson to take that bag out of the car when Ricky Dawson made his exit. And we also know that Ricky Dawson was a barber by trade. And if you look at the video with the dash cam, you'll see that there were items of clothing inside of the backpack, probably his barbering tools from what I understand. So our position is that, well, the driver was a long-distance truck driver. So our position is that The driver had no apparent authority over his passenger's backpack. There was no joint or mutual interest in him and his passenger and the backpack or what might have been aside. So we're looking objectively at the totality of the circumstances, and our position is that the officer was on notice that this backpack belonged to Ricky Dawson, and he exceeded the scope of the search. And we might bring to the court's attention that a backpack is an individualized item that belongs to the owner, much like a purse, much like a wallet, much like a briefcase. As a matter of fact, in State versus Forrester, this court held that a woman's purse is an item where she has a right to privacy in that purse. And when she restricted the search of that purse by pulling it in, the court held that the officer's subsequent search was unlawful. And of course, we have our state constitution, Article 1, Section 10, which gives us elevated privacy rights in addition to what we have under the Fourth Amendment. So we're looking at reasonableness, we're looking at the totality of the circumstances, we're looking at the officer being on notice that there was no apparent authority from the driver to give any consent to Ricky Dawson's backpack. And we're also looking at the fact that there was no affirmative duty where I could find that Ricky Dawson had to make any protest with respect to claiming that bag, especially when the officer stated that he would not have allowed him to exit with the bag. So all of the circumstances combined, we don't have probable cause, and we're asking the court not to use this probable cause as a blanket cure, because looking at this case, we have two different searches that were independent and mutually exclusive of each other. And we have two different answers with respect to, will you consent to a search of this car? So the case boils down to that second search with Ricky Dawson's backpack, and our position is that he had the right to privacy in his backpack based on Forrester, based on our state constitution, and under the totality of the circumstances, the officer was on notice that there's a problem with this backpack. And the driver has not consented to his passenger's backpack, only the car.
Did Mr. Dawson ever articulate, hey, no man, that's my backpack, don't search it?
Well, first
He
of all,
just left it in the floorboard, didn't he, when he got out the car?
well, he wasn't privy to the conversations between the officer
I mean, they
and
were
the
right
driver.
there. I mean, it was loud. Everybody was just right there at the car.
We did not find any affirmative duty where Ricky Dawson had to protest or where he had to. The officer testified.
I'm not asking if there's an affirmative duty. I'm just asking, did he? Did he say, hey, man, that's my backpack, I don't consent? Because I didn't hear anything. I think he probably didn't want to claim the backpack. I probably wouldn't have claimed the backpack if it had been mine.
I understand that.
Yes or no? Did he say, hey, that's mine, don't search it, I don't consent?
He did not say anything.
Okay.
But our position is that the officer knew. The officer's testimony was that he was in direct control, those are his words, of the backpack. That Ricky Dawson, the passenger, was in direct control of the backpack. I could not hear any additional conversations with the dash
barking.
cam between Ricky Dawson and the officer as Ricky Dawson made his exit from the vehicle. So I can't
Okay.
speak to that.
I just wanted to make sure I hadn't missed something and that I didn't hear it, or it's been a little while since I listened to it. But address the two-issue rule for us, if you would. Did Judge Jefferson make an affirmative finding of probable cause? I thought she did. Rightly or wrongly? I mean, I'm not suggesting that was correct.
My reading of the order is that she did not.
Okay.
And I think she made it very clear that we have a rub here. This is a warrantless automobile search, and it boils
Absolutely.
down to consent. And the officer stated, I didn't have any probable cause, that's why I asked for consent. It's written out, but I am not interpreting that order based on that probable cause ruling. And I might bring to the court's attention that in State versus Frazier, which was a case decided last year, that this court has a dual obligation, of course, to look at the factual scenario and to make a de novo legal conclusion on your own based on appellate review with respect to the matter of law of the Fourth Amendment issue that we're raising, which falls under the consent and the warrantless search. So we don't agree with the case law doctrine that has been raised in this court. And I would bring to the court's attention that this was a motion in limine, and it was not final until trial counsel made the objection at the trial, which he did. So this issue is squarely before this court on appellate review. The issue of the warrantless search and the fact that this consent was restricted. And when you look at that second search, you can see that the officer exceeded the scope of the search in the same way that the officer exceeded the scope of the search in State versus Forrester. And we're asking that this court reverse the lower court's ruling with respect to the motion to suppress and utilize the exclusionary rule and not apply what was found in that backpack. Unless this court has any other questions.
All right,
Thank
thank
you
you.
very
We'll hear
much.
you in reply.
All right.
Mr. Farley?
Thank you, may it please the court. I want to start out just clarifying something. This is a direct quote from Judge Jefferson's order. The search of the vehicle and its contents were justified under a probable cause standard 240, and that's after she talked about the automobile exception, did an automobile exception analysis. That's a big, big problem in this case. And we're talking about it being an in limine ruling. That would be a better argument if we didn't have Kelvin Jones that indicated that in the context of these constitutional rulings, they're largely final rulings. And in the end, this is not a situation where when Judge Cooper was presented with it said, I've been presented with extra evidence that I find changes the analysis, and so I'm disagreeing with Judge Jefferson and going to reach a different conclusion. I may find it in consent, but I'm not going to under probable cause. He just said denied. So we have a 21-page order from Judge Jefferson addressing automobile exception and consent as two separate bases. It's just like State v. Hicks. In State v. Hicks, Hicks was really, really unhappy with his probation revocation. And his probation got revoked on 3 grounds. He came to this court with an argument on one of those grounds. This court addressed the merits of it. It went up to the Supreme Court. The Supreme Court granted cert and said, we're vacating the opinion because he didn't appeal all 3 grounds. That didn't happen here. It's a giant, giant problem. And the reason it's a problem is when you don't appeal it, it becomes the law of the case. And if there were multiple independent grounds, there's just nothing left to review. And that's where we're stuck here. But even if we get past that, I still think we're good for a number of different reasons on the merits. First, with probable cause, I never heard anything that ever said there was an empty baggie. The officer tells Carr from the very outset of the stop, hey, I saw what looked to me like a drug bag. And this isn't one where the officer is making stuff up at the hearing where we're hearing his thoughts for the first time. He straight up told Carr, that looks like bags to drug.
You know what I was listening for on the dash cam.
And he said, I know what I saw when he was having that little debate with Carr after Carr got out of the car. And Carr wasn't disputing that there was something there.
No, Carr, I think he, said, hey, yeah, I got trash, I got a candy wrapper, but no baggie, like what we would think of when there's, cocaine in it.
And Carr said at different points in time, he had an explanation for it that was a mint wrapper, an explanation for it was a candy wrapper, an explanation for it was a cigarette wrapper. And so what we've got is Officer Erickson seeing what he said was a plastic baggie with a knotted up end, which he knew from his training experience was the type of bag used to bag drugs. He had a person that acted furtively as soon as Lee mentioned it. He either shoved it in his pocket or shoved it next to the seat. Officer Carr said I couldn't really tell what he did. Then we have the same officer confronting him about it and him providing at least 3 different explanations what it was, which is super, super suspicious because if it's a mint wrapper, it's a mint wrapper. And so that gave the officer probable cause. I know he said he didn't have it, but that's totally irrelevant because an objective standard. And I note, this is what the U.S. Supreme Court had to say in Florida v. Royer when it was confronted with a very similar situation where the officer in that case kept telling everybody he didn't have probable cause. The U.S. Supreme Court's response to that was, Officer Johnson testified at the suppression hearing and the Florida Court of Appeals held that there was no probable cause to arrest until Royer's bags were open. But the fact that the officers did not believe there was a probable cause and proceeded on a consensual or Terry stop rationale would not foreclose the state from justifying Royer's custody by proving probable cause. And the problem in Royer wasn't that the officer didn't think he had probable cause. It was that when the Supreme Court did the objective analysis of the circumstances, it found there was no probable cause. I don't think we have that here. I think we have that the exact opposite.
Well, it's kind of a twist on State v. Retford where the officer had probable cause, just not for the thing he charged the guy with. But you look objectively of whether there's probable cause at all, as I understand it.
He has probable cause, I think, in this case, to think that there's drugs present. And if he has probable cause to think there's drugs present, you got Wyoming v. Houghton, however you pronounce it, which says you can search the entire car if you have probable cause, and it's a car, so the automobile exception applies, and that extends to a passenger's belongings because the passenger's belongings are something in a car. But if we get past probable cause, then I still think we're good on the consent. And I note what Your Honor was talking about before with him not saying a peep when the search is occurring. He knew what was happening because if you watch the video, Carr gives consent to search the whole car after initially trying to limit
Eventually,
it.
there's some good.
At 10:36, he says you can search the whole car. And then at 10:37 on the tape, and this is the first video, Carr turns to Dawson and says, I just gave him consent to search the car. Dawson doesn't chime up at that point in time and say, well, that doesn't extend to my backpack. Don't stop the backpack. And that gets us into the same kind of scenario we're in with Butler, that 11th Circuit case I cited with, where the exact same scenario in Butler played out here where we're talking a backpack. This isn't one of those situations where the officers wouldn't have had any idea whatsoever that it was could have been Carr's backpack. And the best analysis I could think of outside of Butler was for Labor Day, I went down to the beach with some family and friends. And in the front passenger floorboard of the car, my car that I took down there, the entire trip, that was my stuff in the front passenger floorboard because I didn't clean it out. I wasn't considerate enough for others. And there were at least 4 different adults that sat in that passenger seat with my stuff at their feet. And the fact that my stuff was at their feet didn't turn it into their stuff and wouldn't have made it reasonable for anybody that came to my car to think it wasn't my stuff.
So given permission to search the car, does it include searching the contents within
Well,
the car?
It does when the defendant in this case knew what the officer was searching for. So he said, you have my permission to search the whole car, and he knew the object of that officer's search was drugs because they had just had that conversation. And so unless there's a limitation placed on that consent, it was objectively reasonable for the officer under those circumstances to think that they could search anywhere in the car that was going to have the object of the search that the person had just consented to. And in this particular case, for the same reasons apparent authority existed in Butler, it existed for that backpack. But Your Honor also alluded to this too. The third reason that we don't have any problem is the 8th Circuit case is cited to, and Nick's and all of our inevitable discovery case law. We have that dog barking up a storm. It's rearing to get out of that car and do a sniff search. The officer could have done a sniff search if he wanted to, and I think at the point in time that we're at anyway, we don't even have to rely on reasonable suspicion to hold him because I think we had probable cause for the same reason we had it for the automobile search. And he said...
Well, and it's not like they're extending the detention for some unreasonable period of time to go get the dog. The dog is right there.
And if we don't have... I don't think it would even be an extended stop based on... we have probable cause to think the drug's present. We have reasonable suspicion to think drugs are present. So it will give us enough time to at least do the dog search under the Terry rationale. But the only thing that stopped that sniff search from occurring was the fact that Carr said, I'm giving you my consent to search that whole car. And so we never had
Doesn't he say, well, he said to Dawson, I gave him permission to search the car where I was sitting at, and that's page 230 of the record, where I was sitting at.
Right, but that's not what he actually did. He gave the officer search for the whole car. So regardless of what he told Dawson...
He said, I promised just the car right. He didn't say contents. Just the car.
Well, he didn't say to the officer, I'm giving you permission to search my whole car, but you can't look in anything in the car. That's not what he said. And so without any kind of limitation being placed on the search, we have to look at reasonable for the officer to do under those circumstances. An officer that told somebody that I'm looking for drugs, or I'm going to have my dog perform the sniff search, it's not reasonable for that officer to think that the scope of his search had been so limited, he can't look anywhere where drugs might be hidden. Because
Can we move to the issue of issue preservation?
The two issue? Yeah, that's what I was talking about at the beginning. That there's the fact that only a very small portion of the actual ruling below that was appealed is fatal to this appeal for the exact same reasons that it was fatal in Hicks. Because if you only appeal one of 2 independent grounds, then you're just flat out prohibited on appeal from appealing a second or arguing against a second ground. And I'm not following some of the stuff in the reply brief about 2-issue rule doesn't apply if the ruling is wrong, because that flies directly in the face of law of the case, which is an unappealed ruling, right or wrong, is the law of the case. And so I think the ruling was right on both grounds that Judge Jefferson made. But even if it was wrong, if it wasn't appealed, it has to be the law of the case. And the fact that it wasn't appealed in this case basically ends it just like it did in his.
Right, and you mentioned on page 240, and I also noted that Judge Jefferson specifically noted a reasonable and articulable suspicion of an officer will support a finding of probable cause, and the court thus finds that Officer Erickson had sufficient probable cause to believe that evidence of a crime or contraband would be found in the vehicle. And so I would imagine that would need to be appealed in order for us to address it at this level.
Yes, Your Honor, I totally agree with that. And I think, unfortunately, for Mr. Dawson, that's a big, big problem for him at this stage of the process, and it's one that if Judge Jefferson was wrong and I'm wrong and on the merits, then there's procedures that can deal with it at a later stage.
I imagine we'll be waiting for a PCR if that's how this ends up
Yes, Your
working
Honor.
out.
Yes, Your Honor.
Okay.
If there's no further questions, I just very quickly just want to thank the court very, very much, and I apologize for the inconvenience it caused to the court and opposing counsel and Mr. Dawson's family, but it was very much appreciated for the rescheduling.
No, we totally understand, and it's hard for us to hear somebody argue if they can't talk.
Yes,
So, and we appreciate Ms. Carter's cooperation in rescheduling as well. So, not a problem. Thank you, though.
All right, thank you very much.
All right, Ms. Carter, on reply.
On reply.
Yes, ma'am.
As a matter of law, this court can de novo look at the probable cause issue, and we're asking the court to do that.
Can we, though, if it wasn't specifically appealed? That's what I'm struggling with.
In light of State versus Frazier,
Okay.
our position is that this court has an obligation to conduct a duality with respect to the factual issues and the issue of law, the legal conclusion. And that is State versus Frazier. That is our case law. And we would also bring to the court's attention, again, that this was a motion in limine that was renewed at the bench trial, and it was ruled upon. So we have an objection. It's before this court. It's preserved. And we also have this Fourth Amendment claim. So the case law doctrine obviously is not really applicable to a Fourth Amendment claim. That raises this case out of that venue, and we would bring that to the court's attention.
Okay.
Thank you very much.
Any further questions?
No.
All right, thank you, ma'am. All right, fine arguments by everyone. We really appreciate it. And we're going to wave instead of shaking hands. There's still lots of bugs floating around, and, just trying to be careful.
Be upstanding for the court.
Arguments.
Thank you.